And we're live.
Okay. Good morning, committee. Good morning, everybody. Good morning, Chris. And good morning to the public. We're going to spend the first half hour on an update on an issue we've been working for the last decade on, which is misclassification. The last big change in the misclassification world was to bring the AG in terms of enforcement and working with the Department of Labor. I hope they'll join us too, because they could comment a little bit on the report that Chris has produced, which is an update on the issue. The problem we were facing, oh, excuse me, there's my jackapoo again. I'm going to close one door. Hold on. Sorry, so I'm not going to do a lot by way of introduction other than to say that one big step that was made many years ago was to deal with the issue of debarment of people who were misclassifying people for workers' comp and unemployment insurance, and avoiding the taxation or the contributions, and also at the same time potentially depriving workers of coverage. We found out a few years into that there was nobody on the debarment list, which was kind of unbelievable, or very few. And it led to this law that we worked on with Commerce that you may recall, which had some form of joint enforcement with the AG and the Department of Labor. And this report is an update on how that is going. So I'm going to turn it over to Chris, unless committee members have questions right now, and he can correct me and add to what I said and tell us what the report has found to date.
Great. Thank you, Mr. Chair and members of the committee. Good morning. Happy New Year. For the record, my name is Christopher Curtis. I'm the Chief of the Public Protection Division at the Office of the Attorney General, and I am also the designee by the Attorney General to chair the Misclassification Task Force. So I'm here today in that capacity to report to your committee on our progress and provide some updates to your committee and answer any questions that you may have. So thank you for your time and attention this morning. Just by way of orienting you all again and the public, this Misclassification Task Force is made up of several agencies and departments. In addition to the Attorney General's office, of course, there's the Agency of Administration, Agency of Commerce and Community Development, Agency of Human Services, Buildings and General Services, Department of Financial Regulation, Department of Labor, Department of Liquor and Lottery, Tax, and we are charged with not just a review of sort of how we got to this place, because of course, as you are all aware, the legislature has been working diligently on closing the gap of misclassified workers in the state for some period of time now, but also to provide for you an update in terms of statistics, Department of Labor progress on this issue, an update on our joint enforcement powers and how that process has been working, and then also to offer any recommendations to the legislature that the task force deems appropriate. So it's been my privilege to help convene and organize this body. Our charge is to meet at least quarterly. And we have done that over the course of the last year. We were, I think, one thing that the legislature did not require us to do, but that we thought was very important in trying to better understand the issue, was to convene stakeholder meetings. So we did have 2 public hearings in August to invite members of the labor community, members from the employer community, and of course anyone from the general public who has an interest in the topic and wanted to testify or offer their thoughts or suggestions. So in addition to the quarterly meetings, the task force also had 2 additional public hearings where anyone could participate. And we solicited information from those stakeholders if they wished to provide information in writing, or if they wanted to simply, testify orally at the hearings. So in addition, the lawmakers asked us to provide a notice to employers. And so that notice was required of not just of the Attorney General's office, but of the Department of Labor. Not only was the notice posted on our websites, but it was issued electronically, I understand, by email to the department's list of employers. And then in addition, we reached out to the Secretary of State's office because they have a very expansive outreach to the business community through its corporations division. And we asked that they post the same notice or make it available through that mechanism as well. So hopefully there's a little bit broader reach, or if there's a newly incorporated entity, they'll have access to the notice in that way as well. So that's just by way of background and how we operated over the course of the last year. And what you all have, I sent to the chairs of the relevant committees of jurisdiction required by statute, which was, of course, your committee, chair, and also the chairs of the House Commerce Committee, Senate Finance, and House General and Military Affairs, a copy of our task force report, which illuminates our activities over the course of the last year, reviews the data that was required by lawmakers, so the number of investigations or enforcement actions that the department initiated, and then information about the joint enforcement efforts of our offices, and then also looked at the recommendations for the body. And long story short, I think the general take of the task force and what the report concludes is it's very early in the joint enforcement process. We have a small handful, maybe half a dozen of cases that we have taken on in the Attorney General's office at the request of the department. And it's been an interesting process for us. This was a novel area for us to get up to speed on. And it's been, I think, helpful to the department in getting answers from employers who had not been responsive. But because we have our civil subpoena authority, we were able to get answers and or get court orders requiring those employers to be responsive in those cases. So it's been helpful to us in establishing the what we knew to be true, but establishing our civil subpoena authority and generating those orders. And I think it's been helpful to the department in getting the paperwork required.
Looks like you're.
I'd just like to say for the public and for our committee that this report, it had been sent around to all of you by Michael, but it is also on our website under reports and resources. So for anybody who's wanting to follow along, it's right up there.
Thank you.
So we have pursued those leads, and I understand, I think at this time, one of those cases has resolved with a penalty, and getting that entity into compliance. There are half a dozen others, I think, that are in the pipeline, so to speak. So without going into too much detail about any one, that's where we are in terms of our enforcement work in that area.
Can I ask a question on that, Chris?
Yeah, certainly.
One of the problems earlier on is it seemed like, and the Department of Labor got criticized from all different sides on this, is that they were going after some very small entities. Like I remember Horn of the Moon or something like that, a restaurant. Is the case that resolved, or the ones that are they any bigger in terms of like bigger places of employment?
I think it's fair to say these are generally small employers who have not been responsive. And so one challenge, of course, when you're trying to make a determination about whether there's been a violation is whether or if, if you can't get the data or you can't get the information, then it's very hard to come to a conclusion. So, I think that fair to say that for the most part, these have been legacy matters that have been pending for a very long time. And our office has been helpful in trying to get those to resolution one way or the other.
Okay.
That said, I think there's clearly, we're trying to, it's a learning process, and we're available to do this work, and that's our charge. So we take it seriously, and we'll pursue the cases that are referred to us. So with that said, I mean, we could walk through the report, or you may simply want to digest it, depending on, the time you have for today.
We only have about 15 more minutes, but I was hoping that you could highlight what you've learned.
Yeah. And Senator Clarkson, did you have a question or a comment?
Yeah. I mean, how many cases are you pursuing at the moment? Just those two? Did you mention you were just pursuing 2 at the moment?
We have 5. One's come to resolution, and there are another 4 in the pipeline.
Okay.
If there are other referrals that have, occurred since December, we'll take those too. But small handful, I would say. And
are they all slightly smaller employees? By smaller employees, we mean under 20, and they're mostly legacy cases?
I believe that's the case.
Yeah. And so they may be small, but if they become egregious, the more they're ignored, or the more they haven't been dealt with once the employer is notified.
Yeah. And I think, this gets to a fundamental concern of the task force, I think, and probably for both I think it's perhaps the single biggest point that labor advocates and employers agreed on, which is the need for, and I think this has come up over the years, but it's the need for education and outreach on this point. And so I know that there was a notice requirement that we helped to fulfill. That's a piece of it, but I think the question for lawmakers is perhaps what more can be done to provide effective outreach. As you all know, it's super important to the Attorney General to help build a culture of compliance, as he likes to call it, in Vermont, which is that, his belief, I think, is that most Vermonters, given the chance, really want to do the right thing. And so if they're making decisions in whatever area of law, either through ignorance or, negligence, or in the perhaps rarer instance that there's some intentional misconduct going on, giving people the opportunity to understand and get into compliance as quickly as possible is the best thing for our communities. And so education and outreach is clearly a priority. That was, I think, universal among the task force members, that's an area where it seems like, every several years or so, there's an effort to try to amplify the message. And that, I think, is going to be an important potential priority. It's one that the task force has certainly identified. In addition, the task force views the ongoing memoranda of understanding between the Department of Financial Regulation, the Attorney General's office, and the Department of Labor as crucial in developing further this joint enforcement mechanism that you all have laid out through Act 85. Basically the report is new, the law is new, the enforcement mechanisms are new. We want to give it time to work, and the consensus of the task force is that should continue. We're really just at the very beginning of that effort, and we need to see where that will lead in terms of deterrent value. The legislature had also asked us to look at, and we put in the report in the appendices, several companion state references to several companion state reports and activities covering everything from private rights of action to a Private Attorneys General Act, things of that nature. And I think based on the testimony and information that we received as a body, it felt premature to come to a conclusion on those bigger legislative changes that would fundamentally affect not just the, potentially the agencies themselves that currently are responsible for enforcement, but also the judiciary, because it potentially could, create a significant increase in cases for the judiciary. But the question of deterrent value, we weren't presented with any evidence about what either the deterrent value or the beneficial value of changes in those areas might be. So while we did hear some testimony from labor advocates asking for those changes, there was no data provided to us to show how prevalent, are there other cases that the department is not currently receiving that ought to be addressed, or is there deterrent value in those policy changes that would help make a demonstrable impact on the roughly, I think the testimony was 10 to 14% of Vermont workers, may suffer from misclassification.
So Chris, I was going to ask you about that 10 to 14%. I remember way back when we were talking about this, there was some study from, it was then Banking and Insurance, that showed up to 20% of workers might be misclassified to one degree or another. And they were saying that was, the cost of that was falling on the employers who were doing the right thing in terms of their workers' comp premiums. So you said a couple of times here that you found no evidence. Is it, do you feel like it's not your charge to find this evidence? You just have to wait for people to come in and complain to you or make the case? And I thought there was some statement of the 10 or 14% in the report that you were acknowledging that is factual. And now I'm sort of hearing this task force hasn't really even honed down on what the degree of misclassification is, and perhaps you don't feel that that's your charge at all to know whether we have a big problem here.
No, I think it's a great question, and we would like to get those facts. The 10 to 14% was a number that labor had put out, and I think that's or some advocates for labor had represented to the task force. We heard that in testimony. I believe that's also reflected in some national reports, Senator. So the question of a Vermont specific number, and that's a number that may fluctuate, of course, over time, is I think an area of ongoing inquiry for the task force. So I don't view that as a settled matter. This task force will continue to meet, and we will continue to try to the extent that we can, to get information that's relevant to the issue. But I think for purposes of this report, that was the number that we had heard and received both in testimony and I think from national reports. And what we're trying to get a better handle on is what is the status of specifically that number as it translates to Vermont. And another thing I just want to flag for the committee, because I think this is really important as the workforce is currently in a great state of flux, is what is the impact of the new gig economy? There's a section in the report on that. And what is the impact of the pandemic in terms of remote work conditions for folks who may previously have felt like they were tied to jobs in wherever, Massachusetts, New York, California, really anywhere in the country, where now they may be moving to Vermont to be closer to family members, but they may be maintaining an attachment to their employer in one of those other states. And so I think a critical question, we wrestled with this, but I think we're still kind of in the middle of it, is to monitor this area, because the Vermont workforce may be changing fairly rapidly over the next few years in terms of what employer contributions should look like, particularly employers from away who now are employing Vermonters who live here but are working remotely for them. What those employer contributions ought to be, and then how those workers are classified for purposes of benefits. And Senator, I wanted to, in particular, I know you had at one point reached out to me with a question about a Supreme Court case that looked at LLCs in the context of their contributions. And that was a 2017 case called Burbo Custom Homes. And I did look at that case because I was curious to find out if it was the worker misclassification that was the issue, or if it was the contributions that were the issue. Now, the task force was primarily focused on misclassification itself and the impact on workers. But Senator Sorokin, to your point, I think the holding in that case was the workers did need to be classified for purposes of benefits as employees. However, the statute for purposes of unemployment compensation did not contemplate LLCs as individuals for tax purposes. So that may be something, that's a contribution question, but that may be something that lawmakers are also interested in.
Let me just touch on that. Damien is going to talk to us about that case, and I have a bill in to essentially overturn that case, taking the position that the department took in that case. They lost that case, and I think they should have won it, but it's not the main focus of this hearing this morning. And to move us along, in reading the report, unfortunately, I guess I would say, there's very little in the way of recommendations other than to continue the task force. And I'm just wondering, when can we expect some guidance from this task force? We were hoping we might get it by now. We had interim reports and we had this report, but it seems like this issue is a tough nut to crack, and it keeps getting kicked down the road. I think it's an important issue for both workers and law-abiding employers as well. When can we expect some answers?
It's a great question. I think, the committee will continue to meet, or the task force will continue to meet quarterly, and presumably, we can, as a body, we can make recommendations at any time. We're certainly not limited. And I do believe that there is a requirement to issue a second report I don't have the statute in front of me, but there is a second report that's required. So you can certainly expect a legislatively mandated update in a relatively short period of time. So that's the short answer is we can make recommendations to the extent that we uncover facts or policies that seem to militate favorably in this area. We will continue to meet and keep lawmakers apprised. And then we will have a secondary report that issues that you all have already requested.
So it's just a pet peeve of mine. I'll raise it, but having worked in the field of advocacy for a long time, I think this building works, and the executive branch works a lot on where the pressure points come from, and the legislature has asked for help in resolving this problem. And if the advocates for labor or business are not necessarily pushing it while we're not in session, issues tend to languish. And I don't think they necessarily should if the legislature has spoken that we want answers on this. So I would hope that next year at this time, if I'm here and we come back, that we will have some direction on this problem and the extent of the problem, because regardless of what the specific words of the statute may have said, I think that message was clearly delivered that we thought with all these agencies coming together, maybe that was foolhardy on our part, that we would start seeing some corrective direction here. But we don't, I appreciate your time, Chris. I know this has been, believe me, I know this is a hard issue, but I think it's an important one. So
Mr. Chair,
yes,
may I just ask a question?
yes, please.
Thanks. I have two questions for Chris. Chris, it's great to see you. Thank you for getting this started. This is such important work. I mean, Michael, I think that if this task force is meeting quarterly, I would really like to ask us to have to have Chris come back, because if they're meeting quarterly, they'll meet again before we adjourn. I'd love to have an update again, not a year from now, but in like 3 or 4 months, whenever you're meeting next. I don't know when your next meeting is, but because you may have more clarity. And the other thing I'd like for all of us to sort of understand more fully is Vermont's context within the rest of the country. I mean, are we doing a better job, a worse job? I know you have Virginia and Georgia and New Hampshire reports here in your appendix. But I just don't have a context of how is Vermont doing? Are we way behind? Are we, where are we in context with the rest of the country? Which I'd appreciate next time you come, because I know we don't have time today, but.
Thank you for that. I appreciate that. There are, several other states. I would say that Vermont is, along with many of its sister states, looking at this issue closely. And so there are a wide variety of states that have appointed various task forces or bodies to consider, and those agencies are also issuing reports. We try to provide a sampling that got to some of the questions that lawmakers had asked of this task force, so that you could just see by contrast what some states have done. So I think that's right. If I suppose one thing that the task force could consider is, and this may be a summer project for, we have a Steiger Fellow every year that is funded through the American Bar Association. And a great project would be to, perhaps in addition to the work that went into the appendices, actually canvass like every single state and put into a spreadsheet, if you will, kind of the primary findings of each jurisdiction, what legislation, if any, resulted, and then where Vermont fits in with that. Because Vermont will have probably done some of what some other states have either are attempting to do or have done already, and then maybe hasn't done in some areas. And there may be reasons for that, but that would probably be instructive to you all, just to get the whole panoply of state activity in this area, because it's not limited, and that's a major research undertaking. And of course, the principles to the task force, we're meeting quarterly, and we have some resources to devote to finding this information out. However, that kind of deeper dive into what every other jurisdiction has done would require a great deal more time and effort,
Right.
and probably a staff person, or in our case, a temporary hire, if you will, to actually get in there and do that work.
Before we end this, and I recognize Senator Brock, I just want to say, to the extent folks don't remember this, this is a huge issue on certainly a practical and theoretical level. I mean, we have a FedEx kind of employment arrangement. We have Uber with the gig economy. We need to recognize the importance of the gig economy. At the same time, a lot of these people are under control of these employers in a large degree, and are not getting certain employment benefits. So it's a tricky issue, but at the very least, I think one of the things we wanted, because this task force was focused on enforcement, is not the people who have these legitimate claims of whether it's a close call of whether the person is an employee or not. It's the people who are classically misrepresenting the situation, right, and know they have employees and are not listing them as employees. And we have the whole thing with the ABC test you may require, and we have Department of Labor under Trump, who defined it one way, and as soon as Biden came back, it got defined back to the way Obama. So it's very confusing to employers and employees alike. But what I was most concerned about when I was working on this was the classic cases of misrepresentation, and people who knew they had employees and still were classifying them as independent contractors. And I'm not going to cut Senator Brock off, but we'll probably have you back towards the end of the session, and maybe you could at least send us, if we miss it, a report on your next quarterly meeting. Senator Brock.
Just a question. This is an issue that obviously affects many states, and I wonder if we have just sought the information from organizations like the National Council of State Legislatures, which typically does track what's happening in other states on issues of great concern. And that might be a source, if you haven't explored it, that already has much of the information you're seeking.
Right.
Thank you for that, Senator Brock. They do, NTSL does have a page on misclassification. It's pretty cursory. You know, it's sort of, it'll list kind of what the most recent activity is and whether or if there might be a bill. But I'm talking about actually canvassing all of many of those states have also constituted task forces like the one that you have. And so I think as I'm hearing you all discussing and trying to get a sense of, like, you're trying to sort of get a sense of where does Vermont kind of rank in the context of, like, the laws that are on the books, what's effective, what's maybe less so. To do that, I think we would probably really need to dive into each of those individual task force reports, because the state legislatures may or may not act on some of those recommendations. So that's a much bigger canvas. And I think, gosh, we mentioned in our report, but I think there are like 32 or 35 of these around the country that sometimes go in and out of existence, as has happened in Vermont, right? There used to be a governor's task force on this point that went away for a bit. Now there's a legislatively constituted task force. And so some of those reports might be a little older, but I do think that if we really want to get a look at the total universe, that's going to be a much bigger study project to pull all that information in and then really get into the weeds of what's working and what's not, what's been adopted, what hasn't, and then where does Vermont sort of stand in the mix. So I appreciate, you all have done a tremendous amount of work in this area over the years, and I think the laws continue to evolve in Vermont. So it's clear that it's a priority. I think it's just a question of, and there may yet be lessons to be learned from other jurisdictions, and there may be cautionary tales from other jurisdictions as well to be mindful of. So appreciate that.
Yeah. Thank you. This was
and
good.
happy to come back later in the session, certainly after our next.
After your next meeting, it would be great.
Thank you very much, Chris. I'm just going to follow up for 5 minutes on what Chris talked about on this Burbo case. I do have a bill. I don't know whether we'll advance it, probably only if we do other UI legislation, but I've asked Damien to help me explain it, but there was a law many decades ago that said only individuals were, this is the synopsis, individuals were subject to UI, unemployment insurance, and somebody who appeared to be working for somebody else was, I think, an LLC. He had incorporated himself as an LLC, but went to work to somebody else. And the Supreme Court said, a strict reading of the law, and the department opposed the plaintiff in that case, was that it didn't matter whether you were an LLC or an individual. If you were in control of an employer, you had to be part of the UI system. The Supreme Court said the legislature needs to fix this, essentially, if they want that to be the case, because the wording in the statute is interpreted as just individuals and not LLC. So in one fell swoop, anybody who set themselves up an LLC could avoid, an employer could ask, go establish yourself as an LLC, and then I'll hire you, and then I don't have to pay unemployment taxes. So my bill, which is in our committee right now, would just reverse that decision, consistent with the position the department took in that case. So Damien, do you just want to add briefly to that? Because we don't have this was not my intended focus this morning, certainly. Damien? Boy, Damien is really frozen.
He disappeared.
No,
Okay.
Totally. I was,
Well,
there he is. There he is.
okay. I'm going to take my video off because I'm having internet connection problems here in the State House of all places. The case was interesting. It was 5 employees.
What year?
2017. And so there were 5 workers for a construction company, 4 who were just hired as workers, didn't have an LLC set up, and a 5th who had an LLC. the Supreme Court upheld the ruling that the first four were employees covered by UI, but the fifth person, because they were an LLC, and because the legislation specifically calls out or other legal entities or organizations elsewhere in the statute, but in that section it says just individual. They said, well, this person here is doing business as an LLC, so they are not what the legislature intended to cover in the ABC test to determine an independent contractor or determine whether someone's an employee or independent contractor. So in that case, that individual was determined to be an LLC and therefore wasn't covered by UI. The interesting thing with this case and sort of the unintended consequence apart from that classification issue there, where you could set up as a corporate or LLC entity and then be excluded from UI, is that under our workers' comp statutes, that individual could be covered for purposes of workers' comp, so that Bourbeau would have been required to pay their workers' comp insurance, but they're not covered for purposes of UI. So it sets up, a potentially two different standards. It's not for me to say whether that's positive or not, or what the legislature's intent was. But as Senator Sirotkin has said, his bill would basically say if you're a single member LLC or a single shareholder corporation and you don't have employees, then you're also considered an individual for purposes of the statute. So that's a short summary of how his bill would address that ruling and make it consistent with the workers' comp statute.
Okay, we're not going to...
The court holdings on that.
That's great. Thank you. Free time for the chair, but we're not going to get into that bill right now. We may, if we go forward further. At this point, I appreciate that. Unless people have questions more for Chris, we're going to move on to UI in general. We have the commissioner, the director, and I'm not exactly sure of Matt's title, but Matt's with us as well. We all know Matt. So let me just, by way of introduction, we're going to have you folks back, I'm sure, quite a bit as we go through the session. But today we're just trying to get an overview of your agenda, what you've been doing since we adjourned, some of the things that happened since we adjourned. Also, I'm particularly interested in knowing, even though we're not the committee that's going to start on workforce shortages and capacity, I'm very interested in, we sent the message to the department in knowing, do we have any COVID things we need to be doing right now? We did a lot last year to make people eligible if they were contracting COVID and make employers not subject to contributions. We're in a different situation. We've got Omicron right now, and it's not as severe in terms of illnesses and length of time being out, but I'm sure we're hearing about people who are having to take 2 weeks off from work because of COVID. And, what happens to those people now? And do we need any short-term fixes that are remedial in nature? So that's a lot. That's a mouthful. I think we should start off with the commissioner, and he can start us. And as we get into more specifics, we can have questions, and we have the entire morning devoted to this.
Good morning, everyone. For the record, Michael Harrington, Commissioner, Vermont Department of Labor. We also have Cameron Wood, our UI Director, as well as Matthew Barowitz, who's our Economic and Labor Market Information Director or Chief Economist. So each of them can speak to their respective areas. Appreciate seeing you all in 2022. Although I think we've stayed in pretty regular contact even after the session ended last year. So we can certainly give an overview of the department if you'd like, but maybe to the point you just ended with, Mr. Chair, in terms of looking at COVID, which seems to be the most prominent or urgent area that we face right now. I think we would also agree that workforce is one of, if not our top priority going forward, given the workforce shortage that we and every other state are experiencing. At this point, we don't believe there's necessarily directed or specific legislation that's needed for the department or the state to further combat the COVID crisis from maybe the Department of Labor's perspective. That said, I think we're all familiar with the OSHA emergency temporary standard that's currently moving through the court system. So we are keenly aware of that. That's the requirement from the federal government that employers larger than 100 must have either a vaccination policy in place or require their employees to be tested on a weekly basis and report and maintain those test results. I think we have some varying opinions on that. From our perspective, we're what's known as a state plan state. So some states, OSHA actually oversees enforcement in their states. I think there's roughly about 23 states that are state plan states. We're one of them. So really what that does is shift the responsibility onto us and the Vermont Occupational Safety and Health Administration, or VOSHA. And we will need to, if this moves forward and doesn't get stalled out again in the court system, look to implement some type of an emergency rule that is as effective as the emergency temporary standard. So I think we have some thoughts on how to go about doing that without overburdening Vermont's small employers. I think we would say to Senator Clarkson's comment earlier, small employers in Vermont are very different than small employers in other states. So figuring out how to be mindful of that. From the unemployment insurance perspective, we are at, I guess, what we would call pre-pandemic levels for people collecting unemployment. I think what makes this time now different from when we enacted provisions early on to expand eligibility and either additional benefits or additional supports for employers is that now we have a vaccine and we also have boosters. And those vaccines cover a wide age range from toddler and young adult to adult. So from that perspective, there are many more opportunities for protection with our worker community. I think also what we're finding is that more employers have now adjusted their work habits so that there's more flexibility, there's more ability for people to work remote or have changes in shift coverage. So again, I think there's a lot more opportunity there. Or if someone finds that their current employment is not conducive to their other responsibilities in their personal life, they also have a lot of options as well in terms of moving around the employment system. So they could find easily another employer that may offer more flexibilities, if they needed to manage childcare or things of that nature. Matt is here as well, and Matt can certainly talk about the employment landscape in terms of what it looks like in terms of how Vermont's labor force has decreased over the past 2 years, but also what hiring looks like in our workforce landscape. So happy to go in whatever direction the committee would like, or I can just keep talking.
Thank you very much for that. That's a good starting point. I'd like to stay on the COVID thing, and let's get through that issue first, and then we can go more into the other issues. And maybe one of the things I'd be curious is to hear from Cameron. Tell us if somebody comes in with saying, I came down with COVID, and we can talk about whether it makes a difference whether they're vaccinated or not, and the doctor says you got to take 3 weeks off and isolate yourself or something like that, and the person says, well, I got laid off either temporarily or permanently as a result of that, and he goes to you and says, I'd like to draw unemployment. What happens to that person?
Yes, sir. Good morning. For the record, Cameron Wood, Unemployment Insurance and Wages Division Director for the Department of Labor. Happy to try to address the question, Mr. Chair. As a general matter, the first thing we'll look at is whether or not someone has separated from employment. And in the event, we actually did a webinar just yesterday for a lot of employers regarding vaccine mandates and unemployment insurance and the impacts of a vaccine mandate on a potential separation and whether those individuals would be eligible. And I spoke a little bit about this topic. If an individual has been asked to quarantine or is out sick due to contracting COVID-19, and they have an anticipation of going back to work. So, they have a job available, they will be going back to that job after that period of quarantine or illness. We would likely not consider that to be a separation from employment in that instance, and the individual would not be eligible for unemployment. If there has been a separation because somebody is out due to, being sick, the individual, if it's COVID related, would likely not be eligible for unemployment at this point during that period, because a requirement to receive unemployment is that you be able to work, available to work, and actively seeking work. And somebody who has separated because they're not able to work because of COVID, whether they're sick or they are being asked to quarantine, would not be eligible for unemployment at that time because they would not be able to work because of that reason. If there is a separation because of COVID, so let's say, somebody contracts COVID, they're being asked to quarantine, their employer says, no, you need to come to work. And there's a separation there. Let's say the person doesn't show up and they're terminated, or the employer just chooses to terminate, you're going to be out for too long. I need to have somebody here, we're not going to bring you back. In that instance, we would look at that and say, after the period of illness, we would look at the separation and determine that person most likely to be eligible. You can't, if somebody has to quit a job or somebody refuses to go into work because it would be contrary to guidance provided to them by a healthcare provider or the CDC. So, the health department's telling somebody to quarantine for 5 days, the employer's telling them you're asymptomatic, you need to come to work, and the person refuses and quits. We would probably consider that good cause to quit, and we would likely find that person eligible for benefits after the period in which they would, need to quarantine. Once they become able to work again, we would likely deem that person eligible and able to receive benefits. So it's really going to depend on whether or not there has been a separation. If it's just somebody having to stay home with the intention of going back to work and they're out of sick leave, for example, to cover that time period, we would likely not allow them benefits in that instance because they wouldn't meet the eligibility requirements for unemployment. Hope that answers your question, Mr. Chair.
Well, it's a complicated area.
Yes, sir.
Is that different than what our law provided when we did the temporary fix last year, as far as temporary separations, where they're able to eventually go back to work? Do we make any provision for people who were not given their job? or promised their job back?
Yes, sir. There were some expanded eligibility provisions that went into place during the height of the pandemic, primarily to allow people who needed to separate from employment for an extensive period due to a quarantine or taking care of a healthcare member, who is out of work, or needing to take care of children who, because of a school closure or remote work or something to that event. We also had the PUA program at that time, which was designed to assist those individuals as well if they were not eligible for unemployment. A lot of those flexibilities across the country at the federal level, and also the expanded provisions that were put in place in Vermont, have since expired. So at this point, we are back to traditional unemployment insurance program, which would not allow for similar exemptions.
Are you getting some inquiries from people who have come down with COVID and saying, I can't afford to live, I need some help financially, and I don't, I either, maybe I'll have my job back, maybe or not, I don't know how long I'm going to have to be out, but common sense and even CDC guidelines may dictate that they stay away from work, or they have childcare, school closes down and they have to stay home. The commissioner gave us a bunch of examples, and I think they're all accurate, but I'm not sure I come to the same conclusion that it's much different this time around than last time around, and whether we should be helping these people.
I would say, I've received some questions, mainly from employers, not necessarily from claimants. Like yesterday on the webinar that we did, there were a few questions about this issue that we answered for employers that were on the call. I would say we haven't seen a significant increase in claims being filed. Typically claimants don't proactively reach out to us and ask whether they would be eligible. And our typical response, even when they do, is, you have the right to file. It's hard for us to gauge your eligibility without having all of the information available to us. So we try to be very cautious about not being firm on whether somebody would be eligible for their circumstance, because there could be a different party to the dispute, the employer. We don't have that information, so we try to be careful of not advising people that they will be eligible. But I'm not aware of a lot of claimants reaching out to us about this issue, and I also know we have not seen any spike in UI claims related to this topic. We haven't seen adjudications going up related to this topic in particular. No, sir.
So is this, if I got sick, that I had to go out of work for a month or something, and my employer laid me off, I thought there was a disqualification period, but then you could still get benefits. And I think in this case, you said, you didn't mention a disqualification period. You said that in that case, we'd probably award benefits.
So your disqualification is going to be, it's very similar to what you just described, Mr. Chair. So for everyone's benefit who may be listening, if somebody separates for employment due to some medical circumstance that prohibits them from continuing to work, they would not be eligible for unemployment based on that medical separation, because at that point in time, again, you would not be, available to work, which is a requirement of UI. But once your medical disqualification is lifted, then we would look at that separation and determine whether or not you would be eligible at that time. So let's say, you broke your leg and you can't work, and your employer discharges you, at the point in time when you can go back to work. And that's not a great example, to be honest. People may be able to work with a broken leg, but the point being, at the point in time when you're cleared to go back to work and you're now able to work again, at that point in time, you would become eligible for unemployment based on the separation. And that's where I was describing, Mr. Chair, in a COVID situation, if you are discharged, if your employer, terminates you because of a COVID related separation, you may not be eligible for unemployment during that period when you have COVID, if you are ill, or during the period of quarantine. But once that period is lifted, or once you have recovered, at that point in time, we would look at the separation. And if it was an eligible separation and you were able to go back to work, we would allow benefits in that instance.
I guess, I guess maybe I misunderstood the way the law is. I thought that if you quit for health reasons presently, it's as you said, but there's also some period of disqualification even when you're able to go back to work, like a week or something like that, up to 6 weeks or something.
Yes, sir. Let me double check. I believe you are correct. But the point being, once you're let me confirm while we're sitting here talking with the committee, but once the big question is your availability of work, and once that has been resolved, you could then potentially be eligible for benefits. I'll confirm on the medical disqualification.
Okay, Senator Clarkson.
Well, this is it's frustrating, obviously, because here we are in a surge again. We had one obviously this fall, and we managed to get through Delta without UI clearly being impacted, as we're now again at record lows of unemployment claims. But I guess my concern is, what are people doing, even if they're out and their employer's okay with it, what are they doing about income? And I guess that concerns me. If they're out for 2 or 3 weeks, that's a huge economic burden on them. And what's our remedy for that? Is there one? And with no paid family leave, with nothing safe, with no safety net for people, what are we doing about that?
So I'll jump in here if you don't mind. I think the question really becomes, is the unemployment insurance program or the unemployment insurance trust fund the appropriate place for that? And I don't think it is, personally, because it is a health separation and a health reason for not being able to work. And so what ends up happening is we start creating workarounds for regular eligibility requirements that typically would mean someone isn't eligible. So if someone, to Cameron's point, if someone has to leave work due to a medical condition, they would not be eligible for unemployment insurance in normal times.
So then, Michael, is it a workers' comp issue that we should be looking at? I mean, we certainly looked at health concerns at the beginning of COVID, and we put into place measures to support workers who had to leave because of COVID. So we've dealt with health issues already with UI and set a precedent for that. So I guess my question is, does this belong in the workers' comp? Should we be making these workers eligible to access workers' comp more readily?
Yeah, I think those are great questions. First of all, I think the hard part will be trying to compare today to 2020, when we had things like an emergency order, where there were certain federal exemptions and exceptions and federal programs that many of these people would have been eligible for. So many of these people became eligible and moved into the PUA program based on their eligibility. I think, to your point, you are talking more about a family or medical leave program, which does not currently exist. And I think that's the challenge. When we talk about workers' compensation, the only way an individual becomes eligible for workers' compensation is if you can directly tie back the injury or the reason for separation to the workplace. And
unfortunately, as we know, it may well be.
It may well be, but again, you have to, the employee, the burden is on the employee to prove that the exposure and subsequent consequence of that put them out of work was through working. But
I'm just astonished you aren't getting that pressure right now from restaurant, particularly the lodging and hospitality sector, where our workers particularly in restaurants are exposed all the time by the tourists, by who are bringing it in, or by our own unvaccinated, or by by people who've gotten it. I mean,
Yeah,
it's,
and I think the difference though, is that with the change in the CDC guidance, right? So there's no,
5 days, right?
but even if you're vaccinated and you are exposed, you don't need to quarantine or isolate anymore. And so part of that too is with 80+% of our population fully vaccinated, if they are a close contact or fall into the exposure category, they no longer, unless they're, exuding symptoms, they don't need to quarantine anymore. So the level of the number of people needing
Right.
to quarantine
No.
is much less. I also think, go ahead.
No, I get it, but I also get that a thoughtful person, it's still unclear to me how contagious you are in that circumstance. I mean, I know there is CDC guidelines on this now. I'm concerned about people who are, without paid family leave and without UI. Are we left with workers' comp to pick up the week or so that people may have to not be working? And so for people for whom every dollar counts and every week of work counts, what are we going to do to help these people?
So to Cameron's point, I think what we aren't seeing right now is a massive number of people filing for unemployment. So I think it's also hard to know exactly who is impacted and how are they impacted. Right. Because we aren't seeing a significant number of, what we saw right now is even a much smaller uptick than we normally see during our winter session. So even those construction employers or granite shed workers that typically lay off hundreds of Vermonters actually there's such a demand right now that they're actually keeping them on through the winter to do other projects. So again, even the seasonal unemployment isn't as steep as it used to be, at least this year.
Let me interrupt because we'd like to take a break at 10 o'clock. I'm just gonna we're gonna continue with this conversation because I think it's really important. I'm not surprised that there's not that many people applying. I mean, we're in a different environment. I mean, with the emergency order, there were a lot of businesses that were shut down and people thought about, the expectation, I should get unemployment if my business closed. But here the businesses are operating and they lose income for a couple of weeks and they probably don't even think necessarily of unemployment, but they need some income. So we need to talk about that. And I also want to, Commissioner, come back to workers' comp because I had, on a much smaller scale, I had the same question in terms of the presumption law we passed last year and continued. It's very hard to prove with airborne diseases that it was COVID, that it was caught at work. But a lot of these things are going to be caught at work. So let's take a 10-minute break. Scott's been great to remind me about that because I could go on and on, So we'll come back at 11